Most veterans think one VA form, one PTSD label, or one benefits decision can wipe out their gun rights overnight. The scary part is that myth has kept a lot of good people quiet, confused, and one bad decision away from serious trouble. Pause. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a life-changing legal mistake. Hit that button now. Here's why this matters so much. A lot of veterans hear half the story. They hear one rumor at the gun counter, one warning in a Facebook group, one scary comment from a buddy at the range, and suddenly they believe their rights are gone, even when they may not be. That fear can make you give up rights you still have, or worse, it can make you handle a firearm situation the wrong way because nobody ever explained the rules clearly. So let me break this down for you. These are 10 forgotten veteran gun rights that deserve way more attention, especially right now, because some of them have been buried under years of confusion. First forgotten right, a PTSD diagnosis by itself does not automatically take away your gun rights. This is one of the biggest myths out there. A veteran gets diagnosed with PTSD, and right away somebody says, well, there goes your Second Amendment. No, that is not how this works. A diagnosis is not the same thing as a legal finding that makes you a prohibited person. In plain English, having PTSD is not the same as being automatically banned from owning or buying a firearm. Think about how dangerous this myth is. A veteran avoids treatment because he thinks talking to a doctor means giving up his rights. Another veteran skips filing a claim because she thinks the government will label her and report her. That fear can keep people from getting help they need. And here's the part nobody talks about enough. If a myth keeps a veteran away from treatment, that myth is doing real damage. Second, your VA disability rating by itself does not automatically erase your gun rights either. A lot of people hear 70% PTSD or 100% mental health rating and assume that means the person cannot legally touch a firearm. That is not automatically true. A disability rating measures how much a condition affects your life and ability to function. It is not the same thing as a direct federal firearms ban. Most people think a high rating equals automatic disqualification. But the truth is, the key issue is usually a separate legal or administrative finding, not just the rating number on paper. Here's a hypothetical example to explain this. Let's say a Marine veteran has a high PTSD rating, sees a therapist, takes medication, and gets monthly VA benefits. A lot of people would look at that and say, he can't own guns anymore. But that conclusion could be completely wrong. The rating alone is not the same as a firearm prohibition. Don't let a number on a benefits letter scare you into giving up rights you may still have. Third, getting mental health treatment is not the same thing as losing your rights. This one is huge. Going to counseling, talking to a VA psychologist, joining a support group, or taking prescribed medication does not automatically put you into some gun ban category. That is what most people get wrong. They confuse treatment with prohibition. They are not the same thing. And I want you to really hear this part. If you are struggling, getting help is not a confession that you are dangerous. It is not an automatic ticket into the background check system. It is not the same as a court order. It is not the same as being committed to a mental institution. Those are very different things, and that difference matters. Now, does mental health ever affect gun rights? Yes, it can. But here's where it gets interesting. The issue is usually not, did you get help? The issue is, was there some legal or formal finding that put you into a prohibited category? That is a very different question. So if you remember nothing else from this first part, remember this. PTSD is not an automatic ban. A disability rating is not an automatic ban. Treatment is not an automatic ban. Those three myths alone have scared thousands of veterans for no reason. And if you don't know better, you can end up surrendering rights you still have or skipping help you truly need. Pause. If you're finding this helpful, imagine what you'll learn in my next video about the exact words to use when someone starts asking questions about your gun. Subscribe so you don't miss it. Now let's get into the rights that almost nobody explains clearly. Fourth, you have a right to due process before your rights are stripped away. That phrase sounds legal, so let me make it simple. Due process means the government is not supposed to take away a major right based on a vague feeling, a rumor, or casual opinion. There is supposed to be a process. Evidence matters. Findings matter. And for veterans dealing with competency questions through the VA, that detail is a big deal. Here's what shocked me when I dug into this. In the benefits world, competency is supposed to be a serious finding. It is not supposed to be tossed around like an everyday label. The question is not, does this veteran have stress? The question is more like, can this person manage his or her own affairs? That is a much narrower issue. And here's the forgotten right inside that. The standard is supposed to be high. If there is reasonable doubt, that doubt is supposed to lean toward competency, not against it. In other words, the system is not supposed to assume you are incapable just because you have a diagnosis, a rough patch, or a hard year. That matters because once people start tossing around words like incompetent, fear takes over fast. Fifth, a benefits fiduciary issue is not supposed to be a shortcut around your rights. Let me explain why this matters. A fiduciary is basically a person appointed to help manage VA benefits for someone who cannot manage that money alone. For years, that situation created massive fear in the veteran community because many people believed, often correctly under past policy, that a fiduciary-related determination could trigger reporting into the federal background check system. But here's the crazy part. In 2026, the VA announced it would stop automatically reporting veterans in the fiduciary program to the FBI's background check system just because of that status. That is a huge development, and not enough people are talking about it. Why? Because it gets to the heart of the issue. Managing benefits is not the same thing as proving someone is dangerous with a firearm. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And please do not make this mistake. Do not hear this and assume every old record vanished overnight or that every case is fixed automatically. That is not what I'm saying. I'm saying this area has changed and veterans need to know that automatic assumptions are dangerous. Sixth, if you get wrongly delayed or denied during a background check, you have the right to challenge it. A lot of veterans think a denial is the end of the story. It is not. Sometimes records are wrong. Sometimes names get mixed up. Sometimes the system flags the wrong person. Imagine you served your country, walk into a gun store, fill out the form honestly, and then get a delay or denial because your name looks like somebody else's record. That happens more than people realize. Here's what most people get wrong. They think, the computer said no, so I guess that's it. No, you can challenge that result. You can ask questions. You can use the appeal process. You can push for correction if the denial is based on bad information. Seventh, if you keep getting false matches, you may be able to get a UPIN. Now this is where it gets interesting. The FBI has something called the voluntary appeal file, and people who are repeatedly delayed or denied because of mistaken identity can sometimes get a unique personal identification number, or UPIN. Think of it like a tool that helps separate you from someone else's record when the system keeps mixing you up with the wrong person. That matters for veterans because many have common names, old paperwork trails, and records spread across different agencies. If you have ever wondered why you keep getting delayed, even though you believe you are legal, this is one of those forgotten options that deserves more attention. It may not solve every case, but it can matter a lot. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the people who get these updates first and actually stay ahead of the confusion. Click subscribe. Now let's talk about the rights that come into play after a problem shows up, because this is where people either give up too early or make a huge mistake. Eighth, you may have a path to restore rights through state law, depending on your record and where you live. This is one of the most overlooked points in the entire conversation. People hear prohibited and think that word means forever, no matter what. Sometimes it does, but sometimes it doesn't. In many places, there may be state processes like pardons, expungements, set-asides, or restoration orders. Those are tools that can matter a lot, especially if the disability came from an old case and the law in that state allows real relief. But wait, there's something even more important. Not every state process works the same way under federal law. That means you cannot just say, my record got cleaned up, so I'm good. You need to know whether that relief actually restores firearm rights in a way that counts where you are. This is where people get burned. They assume paperwork equals freedom, then find out later the federal side sees it differently. Ninth, there is now growing attention on federal firearm rights restoration too. For years, many people believed the federal relief path was basically dead. Then, things started changing. The Justice Department announced a proposed process under federal law for some people to apply to have their firearm rights restored. That does not mean everyone qualifies. It does not mean it is automatic. And it definitely does not mean violent offenders should assume they are getting a green light. But here's why it deserves attention. It means the conversation is shifting from there is no path to watch this closely, because there may be a path for some people. For veterans who have been told for years that there is absolutely no road back, that matters a lot. And let me be crystal clear here. Proposed does not mean final. Available for some does not mean available for all. If you are in this situation, do not guess. Do not trust your cousin, your barber, or some random comment online. Get real legal guidance before you try to buy, possess, or carry. 10th, veterans still have lawful travel rights with firearms, but only if they follow the rules exactly. This one can save you from a disaster. Many veterans move, they road trip, they relocate after separation, they fly for family visits, hunting trips, or training classes. And every one of those moments creates risk if you rely on military habits instead of civilian gun law. Here's the forgotten right. Federal law can protect some interstate transport when the firearm is legal where you start legal where you end, and transported the right way, usually unloaded and locked away from easy access. But if you don't follow those conditions, the protection can fall apart fast. Imagine you're driving through a state with harsh local rules. You think, I'm a veteran, my old training speaks for itself. No, that mindset can get you in trouble. Your service deserves respect, but it does not cancel state gun laws. The right exists, but you have to use it correctly. The same goes for flying. Yes, you can lawfully fly with a firearm in checked baggage if you follow TSA and airline rules. That usually means unloaded, locked in a hard-sided case, and declared to the airline. Sounds simple, right? But here's what most people get wrong. They get lazy on the details. One loaded mag in the wrong place, one loose round, one undeclared case, one assumption that they'll understand because I'm military. That is how a simple trip turns into a nightmare at the airport. And let me throw in one more warning. International travel is a whole different beast. Do not assume your U.S. permit, your veteran status, or your military background means anything to a foreign country. In some places, even one round of ammo can lead to arrest. That is not fear-mongering. That is reality. So yes, you have travel rights, but only when you respect the rules line by line. Pause. Laws, agency policies, and court rulings can change fast. Subscribe now so you're not the person who finds out too late, after a denial, a traffic stop, or a trip to the airport. My next video breaks down the mistakes gun owners make when they think close enough is good enough. So here's the big takeaway. Being a veteran does not mean your gun rights disappear the second you get treatment, receive a rating, or ask for help. But it also does not mean you can rely on rumors, old barracks talk, or social media myths. The truth is in the details, and those details can protect you or burn you. If this video gave you clarity, hit subscribe right now and stay with this channel. I spend the time digging through the confusion so you don't have to learn these lessons the hard way. And if you know a veteran who still believes PTSD automatically kills gun rights, send this to them today. It could save them from fear, bad advice, and a very costly mistake. Final, simple disclaimer. This video is general educational information. It is not legal advice, and it is not a replacement for a lawyer who knows your facts and your state laws. Always check current law before you buy, carry, transport, or store any firearm.